think the best way to answer that really is dependent on the type of investment structures that they have into the PRC. Most of the deals that we work on are bond structures, but they're what we call offshore bond structures. So typically the company issues debt through a Cayman, perhaps Hong Kong vehicle, and the bonds are issued to offshore investors, typically hedge funds or asset management companies. And unfortunately, the way that these products are structured is that they don't normally have any recourse directly to onshore assets. What they have is most likely some form of collateral over offshore shares, so either the issuing company being a Cayman or Hong Kong company, and also usually intermediate holding companies, which are often BVI or, again, perhaps Hong Kong holding companies, intermediate holding companies. But what they don't have is real security, for example, in the form of mortgages or other fixed charges over the actual assets, which are often and almost always owned by the onshore subsidiaries in the PRC. What that results in is what we call structural subordination, which is the fact that from a capital structure perspective, the recourse of the offshore lenders is really just to holding companies and not to the underlying value, which is always in the operating subsidiaries, which actually own the factories, the real estate, or frankly the business that you've ultimately lent to. And if those onshore assets have themselves been collateralized or mortgaged to onshore lenders, which is increasingly the case, it means that in a distress situation, it's very, very hard to get to those assets because the onshore lenders will usually take some form of enforcement action to realize their security and to get value for themselves. And of course, they are not really that interested in the offshore piece at that point in time, and thus the outcome for the offshore creditors at that point can be problematic. I'm not aware of any specifically, but I do think that this is a big issue for the market as a whole, and particularly given the volatility in the market that we've seen in the last few weeks or months. I would hope that the fixed income community or the bond community would start to lobby for better structures which would give them at least equal recourse to assets onshore with onshore lenders. And I think that is something that the community needs to lobby for, the investment bankers, the buyers of these products. Unfortunately, I don't see any regulatory changes on the horizon, but clearly I think what we will see is that offshore bondholders will potentially suffer as a consequence of defaults in this market. And they're going to learn, unfortunately, quite quickly that their recourse to onshore assets, again, as I described before, can be problematic in these type of circumstances. It's difficult to work directly around the structural issues in terms of the regulatory environment, which doesn't permit onshore, has up until today not permitted onshore security to be given for offshore debt. There are, however, I think, ways to structure around that to a certain extent. Again, the market has been looking at various forms of sort of quasi-security, what have become known as keep-well sort of structures. I personally am a big fan of seeing, let's just say, personal pressure points be taken by offshore lenders. So I think people who are investing in these situations should be insistent on getting personal guarantees from the chairman, for example, or the family members that own the business, and taking real offshore security, if there's real estate in Hong Kong, for example. But collateral that has real value, if it is available, that can be utilised in the event of a default. I think, though, that the real key to being successful in these type of structures is actually really knowing at the outset who you're dealing with. And I think that the people that I think who have been most successful in this space, certainly in terms of the private deals, are investing in companies that they know, that they trust, and that when they commit the funds on day one, that is really just the beginning of their relationship, not the end. So they become, I think, very close to management. They know the business, understand the business, and continue to stay in touch on a regular basis so that they don't find any, let's just say, unwanted surprises. So I think that the lesson in all of this is that prevention's better than cure, and that being diligent at the outset through your credit process and then maintaining vigilance throughout the history of the relationship is the best way to avoid problems. Unfortunately, when it comes to sort of legal recourse, that is really perhaps the worst situation to be in. The legal recourse is imperfect still, and it's best to avoid that at all costs. The answer really lies in the politicism of the bankruptcy law. There is, I think, culturally a stigma still associated with bankruptcy, and so I think that companies and families or individuals that control companies are worried about the stigma of going into bankruptcy and using it as a tool to help deal with their debt situation. I think also the government, and this is why I say politically it's a sensitive topic, because I think the government is very worried about enforcement actions or bankruptcy which may affect the let's just say the rights of individuals, families, and particularly employees that may be working for a large enterprise, particularly a state-owned enterprise, given that the employment relationship is a little different than in the West. The employment relationship is a much more holistic relationship which provides welfare to that employee in many ways, for example, healthcare, housing, and not just a wage at the end of the day. And so I think the perception is if a company goes into bankruptcy and there's any threat to the well-being of the broader stakeholders, i.e. the employees and their families, that of course could be of great concern to the government in China, who, I don't think would like to see instability associated with people out of jobs, losing all their money, etc. I think the other reason why the law hasn't been used is that a law, of course, is only as good as the infrastructure that supports it. And I think that, again, America is probably a very good example of this. Chapter 11 is very successful because we have a very experienced court system in the US that administers the law, and there's a very experienced group of practitioners that also help the courts to administer the law. Unfortunately in China, and the situation is definitely getting better, of course, that this is a new law and the legal system itself is still developing, and we're seeing rapid developments in the legal system. But I think that there's a certain unfamiliarity with the benefits that a law like this could bring to companies that are in distress, and that until such time that the lawyers, the accountants, and the judges who are administering this law or charged with administering it start to have comfort and an understanding of the benefits rather than the possible threats that it brings, is that we won't see it really working usefully until that happens. I think we need to give it time. It's definitely a good law. It has all of the structures and all of the tools that we would like to see in a law like this. It just needs a bit of, I think people just need to have confidence in it, and I think over time we'll see that, and hopefully we'll see it used beneficially for all stakeholders, companies, onshore lenders, and hopefully offshore lenders as well.